Thank you, everyone, for the warm welcome here. It's been just a wonderful time in Ottawa, and Marina and Florian and David and other David have been extremely nice to me, so I've been having a great time. So I want to connect this theme of creating apps for better access to justice to the experience of teaching it and the educational value. And I put the Teaching Tomorrow's Lawyers language in my title because that has been sort of getting a lot of attention lately with the second edition of Richard Susskind's book, Tomorrow's Lawyers, coming out. I don't know if how many people have read any of Susskind's work? If you haven't, you should. It's you should start reading it right now. It's
$15 on Amazon. So it's
and hot off the presses. And he's an accessible writer. He doesn't write dense legalese. He has important ideas about what the legal profession of the future and even of now looks like, and that they're worth thinking about. So in the new edition, which I don't yet have, but there have been some excerpts that law.com website put up and then invited commentary and sort of symposiums and responses to them. And one of those excerpts was about legal education. And it's not flattering to us as legal educators. It's a pretty strong indictment of legal education as not adequately preparing law students for what the legal profession is going to look like. So the quote that I pulled out, he uses the phrase, staggeringly ill-prepared. He's not sugarcoating it. Law.com asked 3 prominent law professors to respond to what he had said and say what they think about how legal education is preparing law students for the future. And Gillian Hadfield, who's another person whose work you should definitely look at, because her work also is particularly relevant to access to justice and how the legal system could be better designed to serve the needs of ordinary people. So her response to Susskind was pretty much, I agree. And the only addition that she put on it was, she said, well, the excerpt from the book, the discussion of legal education in Tomorrow's Lawyers, is fairly focused on big law firms. And she said, I would rather put the focus more on the failure to prepare people to provide better access to justice, to be involved in the legal businesses of the future that are going to help ordinary people meet their legal needs. And as she said, I think Susskind wouldn't disagree with that. His work more generally is very tuned into that problem, and he has very interesting things to say about it. It just happened that the focus of Tomorrow's Lawyers is somewhat narrower, so she brought in that additional perspective. Legal education isn't doing very well at getting students prepared for the different kinds of legal career paths that are going to exist, the probably constriction of the legal career paths that currently exist. And part of that I think is really kind of the good news part of the story is I think there are going to be lots of opportunities that we don't even really kind of have the equipment to imagine yet for people to design and create and bring their intelligence and imagination to doing a better job at serving the legal needs of ordinary people, which the current situation with the legal profession and the justice system, there is a huge deficit. There's a big gap, and that's a need to be filled. And all you smart people with all your brain power and knowledge are the ones who can contribute to filling that. So I believe that we really need lawyers to be involved in finding the solutions to fill that gap, including the technological ones. Technology offers a huge amount of promise to bring services to people where they are, to provide low-cost, fast, user-friendly access to legal information and justice. And I hope the lawyers aren't going to leave that all to the techie people, because I think that we need lawyers to be involved. I think we've got something really important to bring to the table. Lawyers have skills, and on those, like, we do a reasonably good job in legal education, kind of teaching you a way of thinking about solving legal problems. And I think a more important, maybe more inchoate part of it is that lawyers are trained to have a certain worldview and a sense of what justice is and the place of justice in society, and the importance of the rule of law. Without that contribution, I think that merely technological solutions are much poorer solutions to legal problems and access to justice problems. So I hope that we will see lawyers taking a leadership role in technological approaches as well as other approaches to expanding access to justice. So I picked out this example because this is another thing that's been in the news lately, and for me, it's my evidence that I'm right about that the techie people don't do it as well without us. And it's the bot that lets you sue Equifax, right? So probably everyone has heard about the big data breach at Equifax, and people whose information was exposed because of that, may be inclined to seek damages from the company for not taking good care of their information. And this little chatbot thing is supposed to make it very easy for you to sue Equifax for, I think the tagline is $25,000. Automatically sue Equifax for $25,000. So this was developed by a man called Joshua Broder, and he is the brain behind something called Do Not Pay, which is a chatbot that enables you to challenge parking tickets. Started in London. I can see people nodding, so some people have heard of this, and spread out to a number of different cities. He was, I believe, 18 years old, a sixth form student, not a lawyer, when he saw that lots of people were getting slapped with parking tickets that weren't really valid. It was, the ticket said it was at a time when you weren't supposed to park, and it actually wasn't. But it's so much hassle and time and potentially expense to challenge the ticket that it's just easier to give up and pay it, which is almost like a little tiny metaphor for many people's experience generally with the justice system, right? It's too hard to vindicate your rights, so you just give up and, as the phrase is, lump it. So he created this very effective, very simple solution to that, where you could just on your mobile device take a picture, show fill in a form that said the reasons why you were challenging the ticket, little drop-down menu, it was in a different place from what they said, or it was a different time from what they said, send it in, and contest the ticket with minimal investment of time and no investment of money. It's a great idea. It took off. It's very successful. I admire this hugely. I love that it puts power into the hands of ordinary people to fight back against someone treating them unfairly. It's a small injustice, but it's important. And this innovation cuts out the hassle and the time and just the sort of mental pain involved in contesting a parking ticket without this technological tool. Fabulous idea. Does not translate very well to suing a big company in civil court for $25,000. The automatically sue Equifax bot just isn't that good. It honestly doesn't do very much. To file a civil lawsuit involving some fairly complex legal issues, as lawyers I think are very aware, it's much more complicated, it's much more sophisticated than just challenging a parking ticket. The time may come when there are bots that make that process easier and more accessible. I think it probably will, but I don't think that's here yet. So there were a bunch of articles that went around when this came out that said you can automatically sue Equifax with a bot for $25,000, and TechCrunch had a piece on it that with the headline, "No, a chatbot can't automatically sue Equifax for $25,000." And what they said is, in reality, this fully automated chatbot is asking for very basic personal information, like your address, populating it into a PDF. So it's a simple automatic form filler that you can use to start the process of taking Equifax to small claims court. The form is also pre-populated with Equifax's address and the local state agent's address. So I guess that saves you a few minutes of Googling. After you're done using the chatbot, you're still going to need to turn in your form, pay a fee, usually in person, and more importantly, actually show up to court on a designated day and argue your case in front of a judge. While the chatbot also fills in a few words of reasoning, on the New York form, it says that Equifax was negligent under Code Section 1411 in revealing my data. This is meaningless, as you're still going to need to argue your case in your own words. So what it is nothing more than a very simple document automator that slightly reduces the complexity of filing a civil lawsuit, but really no more than negligibly. From a lawyer's point of view, it's kind of a gimmick. It's really sort of tech for the sake of tech, more than it is a genuine solution to an access to justice problem. So I think that law graduates would do a better job with this, and are a great source of ideas that might be better solutions to bridging the gulf between ordinary people and meaningful access to justice. The problem is, and this is, for me, where teaching the apps course really sort of comes in as an answer to this problem. Law students tend to feel like there may not be much that they can do with their ideas. You might have a super cool idea for making it easier for someone to navigate through the process of small claims matter. And you might envision a sort of technological way to assist people with that, but not know how to turn that idea into an actual application. And I can really empathize with that because I share your feeling of disempowerment. I see these ideas coming out and people thinking, oh, you could have a website that would do this, but how do you do it? I am not technologically adept by any means. I cannot code. I have some problems even just running my laptop properly, and I definitely can't teach anyone else how to code. So I have experienced, students of mine coming up with these great ideas. Like I had a group of students who had an idea for an app to assist with court scheduling for motions. So in the courts in Vancouver downtown, and I think pretty much everywhere, the practice is if you're going in for an interlocutory matter, they say come at 10 o'clock in the morning, and you come and you sit around until they tell you it's time to go. And you could be there all day. And if you're on the clock, your client's paying for you to sit around all day. If you're self-represented, that would be a nightmare. You had to take time off work, and you don't know how long it's going to be. And they had an idea for making it a bit more like when you go to a restaurant and they give you the buzzer thing and they buzz you when it's time, so that you've got a bit more predictability and you don't have to sit there, and you could be out of the building doing something else and get a half-hour warning before you come up before the judge. Fabulous idea. They mocked it up, but we didn't know how to do it. Someone should do this. This should exist, but we don't know how. So that's how I started getting interested in finding tools to kind of enable and empower students to turn their ideas into real things. And I found this course that Tanina Rothstein, who spoke here yesterday, really pioneered in collaboration with Neo2Logic, and I thought, I want to do that. So we create these legal expert systems or legal apps. And I think the best metaphor for them, which comes from the director of education at Neota, is that it's like TurboTax for law, right? TurboTax is sort of an interface between you and the complicated tax forms that you have to fill in. And it just asks you simple questions. You plug in the answers to those questions, it populates all the forms, it figures out which bits of the forms you have to fill out. It sort of adds a little bit of reasoning. It's less alienating than filling in the form. It's not the most sophisticated technology. I mean, there are things happening with artificial intelligence and machine learning that are at a much higher level of sophistication, but it can add a lot of value and take a lot of hassle out of the process. And you can map that kind of idea onto a number of legal questions people have, or processes that people need to go through, that this kind of solution can make it easier and quicker and more user-friendly. So Neota offers this drag and drop platform that enables people to create legal expert systems without knowing coding. The coding is sort of built into it. So if you can envision a legal process or the process of getting from a question to an answer as a process, then you can turn that process into a Neota app. The skill really is that thinking through the analysis or the construction of a document or the assessment of a level of risk as a series of steps where one goes to the other, which really is a lawyer's skill. That is sort of part of the way that we think about the world, and quite easily maps into the structure of the Neota platform. So Neota has been collaborating with Georgetown, where Nina Rothstein is, for a number of years to do this course. And that has now spread. There are currently, I think, 2 in Australia that are doing. Melbourne has done it for a couple of years. University of Technology Sydney has recently started. There are a couple more coming online. And there's, I think, a growing number in the US, probably about half a dozen now. And some in England that haven't started yet, but are thinking about it. So it's growing and going
You're
global.
still the only one in Canada.
We're the only one in Canada. Good. Yeah, so far.
Cool.
Yeah. So this is an example. This is one of the ones that my students worked on last semester, and we are rank beginners at this. I am, and it's challenging at the beginning. I don't think I was as effective at teaching them the first time around as I could be, but that's not that surprising because it's the first time. I have a second group of students doing this semester, and I think we got ourselves up and running a lot quicker because I learned a lot from doing it the first time. I had 4 groups. They made 4 apps. We actually have them all up, so if you guys are interested, we can sort of show them to you and play with them. But that's the URL for this one, so you can actually, I see many laptops, you can type it in and play around with it yourself on your machine if you want to. The idea of the animal cruelty app is we collaborated with Animal Justice Canada on this. Obviously, kind of like my pet project, pun intended, because this is my interest. And the problem we were solving, it's not so much a legal question in the ordinary sense, but if you do observe an animal being mistreated or abused, it is very hard to know who you're supposed to tell. If you think of the equivalent situation, if you saw a crime being committed, you call 911. You don't have to worry about which part of the police does it go to or what area, is it Ottawa, Carleton Regional Police or the RTMP or something else. You call 911 and they deal with it. Nothing like that exists for animals. So often what happens is there may be 2 or 3 different agencies or entities that could be involved, and they all say it's somebody else's problem and no one does anything. So, and it's also kind of a barrier to people reporting it because you don't know what you're supposed to do. You don't know who you're supposed to call. You could call 911, but it's not often treated as a high priority thing, so it might go nowhere. You could call the SPCA, but then it can be quite complex knowing which SPCA depending on where you are. Some places it's easier than others. So that was what we were trying to solve, was to make the app take all of that complexity and put it inside the machine so that the person reporting just has to say what happened, where they are, and the app will figure out where it's supposed to go. So just to give you a quick look at what that looks like on the inside, this is the Neota software kind of under the hood. And you can see just from this screen pretty much how it works, right? Like it's the little hexagon things are variables. The clear ones are variables that the user provides. So the system, it's a sort of interview, take information, apply reasoning, and get to a conclusion. So the system asks people these things like, is it a pet? Is it a farm animal? Asks them where they are, and then based on those inputs, decides what's the correct agency to report it to. This is incomplete because the actual information is a bit more complicated than this, so we then went on and did more research about trying to refine and add in more information, but this is the basic structure of how the reasoning works. So, I want to say a few things about teaching this course on designing legal expert systems, legal apps, from a sort of educational point of view. And going back to those ideas I started with about, the deficit in preparing lawyers for the skills that they need for tomorrow's legal world. It's a fantastic experience. It's not easy. It's much easier teaching first year property. This is much more challenging, but it's fun. Working with Neota is fantastic. They're a terrific partner. I find it very empowering to learn this technology and to provide students with the ability to use this technology, because it gives us, it takes away that sort of sense of helplessness that we have, where we're like, oh, I could, this would be great, but how do I do it? Well, this kind of gives us a tool to be able to do it. I think that this is an important set of skills for students to work on, because I am more or less sure that working with this kind of system is going to be part of every lawyer's professional life. Whatever area of law you're in, whatever sort of sector. I find that people are very excited about the technology in this course. It's like the attention-getting part of it, and sometimes the scary part of it. And my students and others think of it as a technology course. But my own view, after thinking about this for a while, is that technology is not the main thing that this course is about. The technology is pretty simple. I mean, there's a lot of complicated stuff in the back of it, but for us to use it, it does not take a lot of technological sophistication. For me, what this course is really more about is equipping students with the kind of flexible professional skills that they need for the legal workplace. And I don't mean just the coming legal workplace of the future, but really right now. All the skills in this little chart, which are professional skills that I think we really develop and enhance through this course, are things that I needed when I worked in a law firm starting in 2004, so a really long time ago, and that I didn't learn in law school. Really none of this. I knew a lot about consideration and not very much about how to understand what a client needs and interact with them and shape, counsel them and shape their need, and also listen to what they're telling me. I never did any of that. So the heart of the work that the students do in this course is each team has to work with a partner organization to develop the app that they're looking for. So they're working with clients. They have to understand what the client needs and what the client wants. They have to figure out a strategy for how they make it happen. They have to manage the client's expectations about the extent to which it can be made to happen given the time constraints and the technology. It's really challenging. It's a lot of sort of three-dimensional chess to ask students to engage in, and it's really invaluable experience. In addition to that, they have to communicate in a way that is quite different from what law schools tend to encourage students to do in memos and papers. Although I think that's changing. I think we're getting better at emphasizing plain language. But in an app, especially one that's designed for the public, it has to be plain and simple. It has to be attractive and user-friendly. There is no point in making a fantastic app that does wonderful things if no one's going to use it. So it has to be something that people look at and think, I would like to use this. They have to figure out how to express complicated concepts in a simple and accessible but still accurate way. It's extremely tough. And this is something that, as lawyers, we should know how to do. That is really our job. Some are better at it than others. This is very good practice at sort of honing that skill. They have to collaborate with each other and their teams. They have to collaborate with non-lawyers. Most significantly, NEOTA, they've got to work with IT professionals. And also with the subject matter experts at their partner organizations who may be lawyers and may not. And then they have to be responsible for their project as professionals. So they've got to be organized, they've got to be reliable, they have to deal with setbacks, they have to problem solve their way out of difficulties, which is something that, you don't really have to do in first year property law, right? You just read a bunch of stuff. And I think one of the most interesting aspects is that students in this course have to sort of make peace with their fear of getting things wrong and failing. That sort of risk-averse perfectionism that I think is fairly characteristic of lawyers and law students. I don't know if it's that we teach people to be like that or if people who are like that come to law school, or maybe it's both. But you can't do that with this. You can't build a system that works if you wait until you've got everything perfect and you know exactly what's going to happen and it's all going to be wonderful and A+, and then make the system. It doesn't work that way. You got to try it. You've got to map it out and show your partner organization and have them say, I like this bit, but I hate that bit, because it won't be a good system unless you go through that process of sort of trying and failing and going back around in a circle. And the students' reluctance to do that and fear of failure is a real obstacle and can hold them back from pushing the projects forward. So a big part of the educational experience is kind of understanding that, coming to terms with it, and moving ahead. So compared to all of that stuff, learning how to use the technology is really pretty simple. It's the courses is sort of a shift of gears. There aren't answers. I don't have answers. It's up to them to find the way to a successful project, and there might be a number of different ways to get there. So there are times when that is quite difficult and frustrating for the students, but overall I think all of us found it tremendously rewarding. And I had one student from last semester who said this was hands down one of the most innovative and unique classroom experience I've had. So I love that, and I like to tell people that because it makes me feel happy. So that's sort of the opportunities side of it. A lot of positive in this. What are the risks? It's like not all a happy story. Overall, I love this. I don't want to stop doing it. It's great. The sort of things that you think about and don't want to ignore on the risk side of the ledger. So generally, there are risks and shortcomings associated with apps or expert systems as a solution to justice problems. I won't spend too long on that because I don't know if any of you were here for Tina Rostain's talk yesterday, but she did a very good analysis of those problems. So just in sort of summary form, unauthorized practice of law, if you build a machine that helps people to draft legal documents, that provides them with an answer to a legal question, some might take the view that it's giving legal advice, which is something only licensed lawyers can do in this area of sort of technology-enabled justice services. There has been controversy and indeed litigation about that, and investigations by law societies and so on. So we try to, my main protection from that is that none of our apps have gone out to the public yet, so we're safe now. And we also try to design around it by having a disclaimer, by sort of framing everything as information. It's sort of tailored information. But I recognize that, that is a risk. There are potentially issues with privacy and information security. Apps can collect, like the Equifax bot collects some personal information from the user. And depending on, how good the protection is of that information, there's risk involved there. Lack of reliability, so your app could be wrong. Right, it's only as good as you built it, and also the law can change, or the best practice sort of answer to the question can change, and it may not be maintained over time. Especially these class projects, they tend to be done at the end of the semester. For a lot more on that, wonderful researchers here at Ottawa have done a excellent study on the risks and opportunities of technological solutions to access to justice problems. So lots and lots in there. So one category that is one of the categories that the McGill paper looks at, but that I wanted to kind of highlight here, is the sort of like attraction of tech, the sort of like tech is shiny and sexy and it can solve everything, that might make our critical faculties not as sharp as they would be about other kinds of solutions. We can think because it looks cool and you can put it on your phone that it's great, and it may not actually be that great. I think the Equifax chatbot is kind of an example of that, right? I mean, it's like, oh, it's a chatbot, it's exciting, but it doesn't really do anything. For us working with Neota, a drawback is platform dependency. Neota is fantastic because it enables me to do something I couldn't do otherwise. I've got the technology that I can use despite being a tech dunce. I've got the support and the experience of the professionals at Neota. This is like an on-ramp to me for things that I otherwise am not equipped to do. But the flip side, the downside to that is I can't do it without Neota. So we can't, I mean, in theory, we could take the designs that the students have created and transpose them to another platform. And there are sort of open source platforms and so on, but that's another level of difficulty. And it means that, you know, the organizations that we create them for aren't going to have access to them unless they have an ongoing relationship with Neota, or unless someone builds it in a different platform. So those are both sort of, it's just less easy. It's just a sort of barrier. And that also makes it a bit more difficult to maintain them, because it's only possible to go in and update if you can get into the Neota platform. So my overall thoughts about all this is, I hope that this is a beginning and we sort of grow better infrastructure to empower lawyers to use technology for justice. That this is just one way to do it, and that over time, you know, there will be lots and lots of different ways that are more accessible, and there's more diversity and more choice. So we'll finish with my closing thought from my favorite Twitter account. AI and tech are going to do a lot of things that lawyers used to do, but it will never replace us completely. And that's the end of my talk, and Marina and I are going to have a little conversation about it.
Yes, so thank you, Katie, that was really great. And I think we will, Florian, can we look into doing the Yoda thing? So that we have to dethrone Katie.
If you want some intros.
So I think I'm going to start with that particular question. So law school attracts students or people who are not necessarily perfectionists, the other way around, who are perfectionists and not necessarily able to work in an imperfect world. But us teaching law are usually like that too.
Yep.
So how do we balance teaching, innovation, and doing these things where we ourselves don't even know what we're doing, because the world is constantly changing.
You just described my experience completely.
So, and I think the challenge for me is not just maintaining authority in the classroom, but also working with that anxiety of law students where there has to be predictability in assessments and deliverables, et cetera. So, and I have no answer to it. So I'm looking to you in terms of how have you worked within yourself to do that, where you balance like, oh, it's really great, but we really don't know where the world is going to be in 5 years and how it's going to look like in terms of what kinds of technologies are going to be available.
Okay, there's a lot in that. I think there are kind of, sorry? Oh, okay. There are sort of two.
Yes. The video thing.
Oh, yeah, the video
I will
thing.
come here. Yes.
There's kind of two like themes in that. There's a small one and a big one. So at the micro level in my class, I have learned by my own shortcomings and sort of developed a couple of strategies that have helped. So one of them is, has anyone ever heard of the failure resume or the failure CV? I think it's been around for a while. Someone wrote a CV of all the jobs they didn't get, all the grants they applied for and didn't get, all the manuscripts they submitted. It was an academic CV. Manuscripts they submitted that were turned down, etc., etc. And then it sort of spread around. But someone wrote an article about it and wrote their own failure CV. So I actually did that as an exercise in class. This is not a traditional law class. I was telling my colleagues about it. I'm like, you probably think I'm really flaky, but we did our own failure CVs in class. I got all my students to do it, and I did it, and it was a fantastic experience. We had a lot of fun. It was very funny. We all talked about very funny things that we'd messed up on, but it was kind of like I think it helped all of us to sort of move down that path of making peace with our failures and sort of realizing that they had helped us. And there was a lot of people talking about, I didn't get into this law program or didn't get this job, and I'm glad I didn't, because now I'm doing this other thing that worked out much better for me. So that was one solution. Another really small solution I have is I've got in this course, I have a lot of assignments that are just do a first draft of this thing and bring it to class. And then you get a point. I'm not grading it, I'm not evaluating it, I don't care if it's good or bad, I just want you to do it. And it sort of gets people moving. And then that builds towards a final product that actually is evaluated. But just that sort of kickstart to get people moving, it makes a big difference in the quality. So those are my micro solutions. The bigger picture is, I think you're kind of asking, like, are we irrelevant? Or like, are we at risk of being irrelevant soon? I don't know. Maybe. I'm just trying not to.
I don't think so. I think for me, the challenge is really, so it's all bright and new and shiny.
Yeah.
So and I think, I liked what you talked about, that it really isn't about technology, it's about transferable skills.
Yeah.
And teaching thinking in a different way and organized thinking in a different way, so that it can be applied either to a particular technology or in the future to a specific, very concrete legal problem working in an environment. So I agree from that perspective that it is really much broader than just the technology. Technology just makes it more attractive. It's like, we're going to teach you how to do a flowchart of a specific legal problem. People would really take the course, right?
And that's really all this
is. We're going to teach you how to build an app.
It's not really anything more than that. Yeah.
It becomes really interesting as well.
So those things, there is nothing new or 21st century or tomorrow's lawyers about these skills. They translate into different contexts, and I think there are lots of successful legal professionals who've had careers that span a lot of different contexts, and where you think, how do you know what to do when you're going from this thing to this completely different thing? And there are skills that translate across those barriers, and building them and learning them, whether it's through a tech course or otherwise, that's going to be a valuable asset that you can take with you into a future that is going to change, but some things never change.
So I have another one. So we talked, and you identify that as that it is highly platform dependent.
Yeah.
So Neota is a platform. There are many others, and there are platforms for dummies, right? Mm-hmm. And there are platforms for people who can actually code and do things that us humans cannot. But I'm just wondering, and it's something that I've talked about with my students in my classes. Because we're so platform dependent, are we actually then reducing the complexity to a level where it becomes useless? And are we helping people by basically forming their opinion rather than the other way around, where technology really helps them? So, people often are not able to identify legal problems. They just say, like, let me tell you what happened to me, rather this is a specific legal problem. So there is some triage that you have to initially do once they get into the specific platform. But are we imposing our own ways of how one ought to think or how one ought to resolve their problems
on users?
Yes,
people who use them. I think that's a potential risk, and to me that is. I don't think necessarily. I don't think that's inherent in using an expert system type of design. I think it's a matter of a good design versus a bad design. So I mean, just as one example, like one of the commercial expert systems that Neota created for a law firm is for compliance with the Foreign Corrupt Practices Act in the U.S., which is basically like you can't bribe foreign governments.
Really?
unless you're the president. But so they have an app that a company, a multinational company's personnel overseas can use to get sort of a quick kind of risk check on something that they might have been asked to do, like attending an event with an official or something like that. That app is designed so that there's a yes and a no and a gray area option. And the gray area option is about 80%. Like it's designed to drive most of it into the gray area option and sort of triage off the ones that are very simple, no problem, or definitely a problem. So it doesn't oversimplify the problem. It's for a law firm, so there's a business aspect to that too, like the ones in the middle call the firm and get advice about it. But it's a design that understands that there is a lot of stuff in the middle that's gray and complicated and doesn't misrepresent that, but it helps with the stuff that isn't. So it's certainly possible to have those kinds of designs. There's nothing inherent in an expert system that it has to give you a simple answer to a complicated question. So yeah, I don't know if that really answers it.
No, it does, and I think it also depends on what kinds of, so I'm a big fan of expert systems. I think they're very helpful, but again, maybe in 5 years we will say, oh, that was so, 1934, what we actually did. But I think they're a good first step, at least, in helping people articulate what kinds of issues they have and lead them to specific pathways.
Yeah, and just, save some time in the places where it's easy to save time. And also, I think there's almost a sort of like an affective aspect to it as well. I know that, dealing with a machine in some ways is less sort of emotionally rewarding than dealing with a human, but I would say that it can actually be better, because like lawyers are not famous for their interpersonal skills and sort of warmth of personality, and dealing with legal problems, it can be very fraught and stressful. And actually just like the completely neutral situation of dealing with your screen is, if it's well designed and gives you sort of reassuring messages and is just like gives you a sense that like you're not all alone and that there are answers, I think that can be a really good complement to interaction with human lawyers. It might be less intimidating than going and having a first consultation with a lawyer, which is a very intimidating thing for a lot of people.
So, and you use the Equifax bot. So I'm just going to say there's an arbitration clause, so you can't even sue them even if you wanted to, right? Which may not go through in New York, right? Which is not. But so can we talk just a little bit about multi or pluridisciplinary teams developing these? So there are inherent dangers in techies designing bots. There are also, I think, inherent dangers in lawyers over lawyering. I agree.
Specific. Yeah, there's a happy medium somewhere, right?
So So I know that in your class you have law students only. Have you considered bringing in other experts? Because I have done that, and it is actually proving to be very, very useful.
I would love to. I'd really like to. There's a computer science professor at TRU who I really like, and we like meet up and like bounce ideas off each other. And I have to say, like there is a very simple obstacle to my doing that, which is a matter of institutional design.
Can't cross the courses. Yes,
it's cross courses. I mean, it's not that I absolutely can't do it, but if I wanted to do it, I would have to go through a lot of administrative headache. And then I think what would happen is I'd get like half of the work credit for it that I would if I taught a course on my own. And I would not be doing half the work. And so I just think about that, and I'm like, no, I'm not going to do that. So, I absolutely see the benefit, but I'm somewhat altruistic, but not that altruistic. So I would love to.
I did fight that battle for a bit, and so I have one of our law students who has a master's in library and information studies, and I have somebody who's currently doing master's in library and information studies is taking my course, and I'm finding it incredibly useful because librarians think this way, lawyers don't necessarily, so it's a very interesting conversation and a skills transfer that's happening in terms of enhancing thinking and research skills. Ellen?
And that's invaluable.
I think that librarians may have some of the skills,
Yep.
that the techies have, but they should also have the communication skills, and you really need the social scientists in there, because you need someone who knows how to design surveys. You know, what does it mean to, and I think we don't give any credit to that part of the profession in these kinds of things, which is why some of them are terrible. And you need people who will evaluate at the end of the day what biases are in the system.
But also design impact factors and how do we evaluate if the system is successful? Like what do we want to achieve, and how do we measure what we have to? Because and I agree with you. Like for us, it's really super shiny. It's new. We're creating these apps, but the true value is really are people going to use them? And I think a bigger issue that we're struggling in my course right now is like, how do we really get the apps to the people who need them? Like, so we've created something that is very helpful, but that public awareness part needs to happen, and we haven't really figured that one out yet. And Tanina was talking yesterday that, you know, there are multiple apps doing the same thing. Right. So how, like, all of a sudden then you're competing, and all that we want to do is really help people resolve problems so that, you know, they can actually have happier lives.
And it just makes everything more confusing, and, you know, you don't know if you should be using this one instead of that one, and
So I think I'm going to park. I have a few more questions for now, and open it up to the audience. Yes.
I have two questions.
Yeah.
Regarding pretty much the same topic. You were saying that your students, they pair up with organizations, to develop the app. My first question is, can you give some examples of to like what area of the law they're from, just to see the scope?
Yeah.
And the second question is, you mentioned the risk of the reliability.
Yes. So
how do these organizations, do they have concerns regarding the reliability, and how do they address it, or how do they work with the student on that?
In answer to the first question, I can show you the ones that we did the first time around, and I'll just tell you quickly about the current projects. So this one, it's very diverse. This is, you know, there's a lot of flexibility in this. You could do a lot of different things with it. So this one, the organization was National Self-Represented Litigants Project, that's based at Windsor. And this piece is using their database of lawyers and other professionals who have told NSRLP that they're willing to work with self-represented people on a limited scope basis. So it used to be, really, there were just two options. You were by yourself, or you hired a lawyer in the traditional way on retainer, and it took as long as it took, and it cost as much as it cost, which is impossible for most people. So there is now a growing movement of legal professionals, including paralegals, and they also have other kinds of professionals in the database, like editors who will proofread if you're preparing your own documents. And we made a database to make it easy to find the right person out of that database. So it's a database search tool. It's very simple, and you just, you know, pick your area of law and where you are and a couple of other options, and it will just search and find the right person for you. So that's pretty simple but helpful. This one we made with David's organization, and this is to help people if they get a demand letter from a
which nobody ever got, but you all know what we're talking about.
Yeah, because
like
you've never
that last episode
copyright.
of Games of Thrones, right? That you watched and you weren't really supposed
also,
to watch.
you could get one if you actually haven't infringed copyright, right. So that could happen. So yeah, letters from, we call them copyright trolls in a very, very neutral and objective manner. And it's to ask a few questions which are not entirely legal questions. It's a decision based partly on the person's tolerance for risk, and the identity of the sender of the letter, which also indicates how aggressive they might be and whether they might be inclined to sue. So taking that information and says, you know, here's some ideas about what you could do. You could answer and say, I didn't do it. You could answer and say, sure, I'll pay. You could wait for them to sue you. So it's more of a sort of advice about procedural steps than, not advice, information, than legal. That's the animal one which you saw. This is very cool. And again, it doesn't really involve legal analysis. It makes it easier to fill in family-related court forms. So there might be any number of them. Oh, maybe that'll come back if I try it again. But there are lots and lots and lots and lots of court forms, and this is for a women's legal clinic that deals with a lot of family matters. So there's different courts as well. And a client or a person working at the clinic with a client might have to fill in 5 of them or 10 of them and put in the same information lots and lots of times into different forms. So what it does is that the first screen, which I would be showing you if it was working, has the list of the different forms. And you can pick, okay, I need this one, and this one. And then it knows the common information from those forms, which is, the name, the court file number, the location of the court, etc. Asks you to put them in and then automatically populates them all. So it just speeds up and makes that more accurate.
It's working.
Oh, there we go.
It really be like TurboTax.
Yeah. I mean, it really is the same idea. Yeah. That one, this is not one of ours, but I just had this up as an example because I really love this. Neota and some people who care about immigration law rolled this out in about 24 hours when the first Trump Muslim ban came in January. And you remember those scenes at the airports where there were volunteer lawyers and there were throngs of people and people were sort of trying to connect up. So it's an easier way to connect a person with a lawyer. And when it first came out, the only airport they covered was Seattle Tacoma. And you could go onto a little form. It asks the flight that the person is coming in on, their name, a couple of other pieces of information, like why they were affected by the ban, I think. And then you click it and it just gets sent to an appropriate lawyer who then says, okay, I'll come to the airport and meet this person. And you give your contact information. So it's designed for people who have like family members or friends or contacts coming in. And then the lawyer can call and get more information and you can like coordinate with each other. So a funny story showing my own sort of lack of common sense sometimes. I went onto this and I was like, oh, this is so cool. And I had been messing around with Neota dummy applications for a while, and I wanted to see what it did next. So I put in fake information, and I clicked the next button, and like 10 minutes later, a lawyer from Seattle called me and asked to speak to Mr. Made Up Name, and I was like, I'm really sorry, and I explained the situation. I said, I'm teaching students about this, and I didn't realize it was going to go to. We ended up having a lovely conversation. She was really nice, and she said she was jealous that she wasn't in Canada, and we had a lovely time. But since they rolled out that basic version, they added on all of this stuff, so lots more airports, including Canadian ones, different languages. I'm not going to do anything else with it because I don't want to accidentally call a lawyer, but it's a great, it's a simple idea. It's right, like help person A find person B, but it just makes it easier and it adds some value. And the ones we're doing currently, so we're doing more work with animal justice, more work with Self-Represented Litigants Project, and the wireless code. We're doing an app to help. It looks like it'll be to help people file complaints with the CRTC about violations of the consumer code that protects consumers in relation to mobile plans, and another one that I can't remember right now. Oh, our own clinic. So True's clinic. We're going to do probably a document automator, so wills and powers of attorney and stuff. So it's really, it could be anything.
Yeah.
It could be anything. There's just a huge variety of things you can do with it.
I think that's the beauty of it, where it can literally be any area of law, and what most people think of it, it's a technology, so technological solution, therefore it has to be an area involving technology, and it actually isn't.
Yeah.
And the narrower the area, the more helpful the app is going to be, right? So it can be a simple problem like putting two different kinds of experts together, or something a little bit more complex, but the more refined it is, if it's too general, then it's not necessarily helpful. And people are just spinning in circles, and you're one of the things that they might consult. But if it's resolving a very specific problem.
It's
So the
also
one that
much
we're
harder
gonna-
to build if it's big and
So the one we're going to talk about tomorrow with an Ottawa group called Connecting Ottawa is to develop an app similar to what Tanina was talking about yesterday, legal health checks for social workers, to help them understand when people experience legal problems and where would be the appropriate places to refer them to. So that one turned out to be a little bit too big for this one, but we're going to explore. So it really has, areas are really not relevant. It's the problem identification, and then how do you resolve the problem versus what area of law that involves.
Neota says in their sort of training / marketing stuff, if you can imagine it, you can build it. And with Neota, so it's really about what can you imagine? Like, can you imagine this? There was a second half to your question that I've completely forgotten now. Sorry?
How the organization perceive the students are working. Is it
Right,
reliable?
the reliability. So at the stage of building it, that's part of what we rely on the experts for, is to look at the rules that they've built in and say, oh no, this is wrong and this shouldn't be the outcome, and it's a sort of back and forth process. The more challenging part is after, because things can change, and at that point the students are gone. So in real life, I haven't dealt with this problem yet because all the apps we've done just sort of haven't got to the stage where they would go out to the world. Tanina's students have done some, and I really how it's worked is they have become the property of the organization, and they then are responsible for maintaining it. But it's challenging. It's a difficult part of this because that requires someone to know enough of the Neota system to go in and fix it. And it's not super hard, but it takes some investment of time, and non-profit organizations that are already stretched, that can be a
It's the
barrier for
resource
them.
issue.
Yeah, so I don't really have a solution to that problem. I'm aware of it, and I don't have an answer. David?
I'm interested in the conflict between Neota's marketing slogan, if you imagine, you can build it,
Yeah.
and the Law Society rules, because I can imagine
Yeah.
things that would violate the prohibition on the
Mhm.
unauthorized practice of
Yeah.
Have the American Bar Associations and the Canadian Law Societies, have they come down with any kind of guidance on what you can and cannot do for these kinds of acts?
No, and when I was thinking about sort of needing infrastructure to empower lawyers to do this kind of thing, that's one of the things I think about. I would love, this is a sort of, hypothetical world fantasy, but I'd love to see a world where law societies help lawyers do this, including by saying, you can do this, this, and this, but don't do that. But there is nothing. I think law societies should do that because their job is to regulate the profession in the public interest. I strongly believe it's in the public interest that these sorts of tools be available and that lawyers take part in developing them. I am sure people will develop them, whether it's lawyers or not, right? So I'd rather it was lawyers, or at least that lawyers are involved in it, because I think they will be less good and less reflective of principles of justice without the involvement of lawyers. The closest, I think, to some sort of analysis of what constitutes unauthorized practice in the context of automated stuff is LegalZoom has been kind of chased up by a number of bar associations in the States. And they've had a pretty good record of succeeding in those lawsuits. And my understanding is that it's been on the basis of sort of restraint of trade laws in those states. So on the one hand, the Bar Association is saying, you can't have. Do people know what LegalZoom is? It's a document creator. It does more as well. It says like a lawyer referral service now as well. But you can go to LegalZoom and you can pull up a template and you can make a will. So it's kind of like one of these things. You put in the information and it spits out a will for you. It's like buying a will kit at Staples, but it's got that little bit of automation in it. It does like basic incorporation. A few other things like that. And there's other stuff that they've started doing, like lawyer referral. But some of the bar associations in different states came after them and said, what you're doing is the practice of law, you're creating legal documents. And in those legal disputes, often there were also sort of state laws about monopolies and restraint of trade that kind of saved LegalZoom. So it is a big unresolved question. My own personal view on it, and I'm well aware that my own personal view is not an answer to the risk that the Law Society might see it differently. But my view is, if there's a very simple, I can call it AI, but I think a lot of AI people would say it's not even that, right? It's not complicated enough to be AI. It's like this very basic reasoning where you plug in this information and the answer is this. I don't think that's the practice of law. If it is, I don't think our job is very complicated. There was someone who was at the workshop on Monday who is a developer said, do you think that if you type in a legal question to Google and Google provides some answers, is Google practicing law? And if the answer to that is no, then how do you, hypothetically law societies, how would you draw the line between that and a little simple piece of technology that sort of just makes that same process a little bit easier? I agree with that, but I don't think regulators necessarily
I have a quick comment that I'm going to bring you down. So, two things. I think a lot of the times law societies see this as turf protection, and this is really not turf protection. People who use these apps are not people who are going to take away jobs from working lawyers, because these are the people who often cannot even afford lawyers. And then number two, what I'm going to say? Let's not wait for the Law Society to give us guidance. Let's sit and make a policy paper and then use President of CULT to work with law societies and let's just change it. Or let's not wait for another 6 years and somebody to be, prosecuted by the Law Society for an authorized practice of law. Let's just figure out how it would look like. We have hive minds. Let's have 3 students working on a directed research paper. Let's do that.
Great idea.
So
that'd be a cool project.
that Ellen?
Now, the projects that you illustrated are not quite yet crossing a line. There are the more sophisticated, you sort of refer to them at the beginning, artificial intelligence, but the legal expert systems, which are, because there's a lot of decision making that goes into what goes into the decision tree, and a lot of biases that go into that decision tree. And when Marina suggested that, are we creating a program where people are going to have to, we're telling the user what to think, those programs do. I'm not even necessarily critical of them, but I'm not going to turn my head in the sand and say that they don't, because they do. And I think that's that's almost the more important challenge, because they will not just be used, those programs, by the person who doesn't know what to do in small claims court.
Yeah.
So that's just one thing. And the other thing is, I think it's important that you did turn it over to the organization so that they are responsible for the maintaining of it. But that does leave you without a mechanism for then a long-term project that reviews what its value is.
Yeah.
And I know that the tribunal out in BC is building on years of Colin Rule's experience.
Absolutely.
And his failures and all the things he learned when he was working for the big guy, PayPal. And so it would be really smart to do that. And my third point is, I love the interface on this one. And what you learn from looking at this is the importance of graphics, font, white space, clear language, which is one of the points you made in your teaching, that the students have to teach that. And that's a whole level of new skill set that...
Yeah, and again, it's not that new, I mean, maybe the graphics stuff is, but,
Well, we teach it in legal writing.
Yeah.
It's just that legal writing has been, not really well taught in most places.
Yeah.
But we teach it in first year. All you lucky people who are taking our first year program.
But most important course in law school.
It's the dispute resolution course, right?
Yeah.
But there is the, but it's stark. It's shocking when you look at the difference between there, and I could even edit this one a bit.
Yeah.
But
David, should we be wrapping up? Or do we have time for
I
one
think we
more?
got time for one more question. Comment?
I thought there were a couple of people over here. Yes.
So I thought that was really cool, and I just thought that was very interesting. As these apps become more prolific,
Yeah.
would you see a concern where if people are trying to decide if it's the right idea to like go to legal counsel or try to like rely more heavily on these like supplementary tools, that if they rely on these tools, they'll have a lower quality sort of like legal resource to draw from? Like, are you worried that these won't give the same sort of like breadth and like quality of like legal assistance that some people might need if they rely on the apps instead of people?
I have no doubt that you would get better service if you could go, as long as it's a decent lawyer, if you could go and sit with a lawyer and talk through your problem. I think what these are primarily aimed at, some are not aimed at the public, right? Some are sort of internal tools like the clinic one to just make people's time use more efficient so that they have more time for other things. But the ones that are for members of the public to use, I think the option is nothing. That's really the hole that we're trying to fill, right? So it may not be a high bar to be better than nothing, but I think we can meet it. I think we can do that. I don't think we're talking about people who have the option of going and sitting and having a consultation with a lawyer, because if they could, that's what they would be doing.